Good evening, students. Uh, so this is the next part of the topic, remedies for breach of contract under a sale of goods contract. So far we have discussed the remedies available to an unpaid seller, which we also called rights available to an unpaid seller. The second part of remedies for breach is the remedies available to a buyer in case a breach is done by the unpaid seller, by the seller. So what kind of breaches a seller can commit, and what kind of remedies then will be available to the buyer. So one by one we are going to discuss with all these. First remedy available with the buyer will be suit for damages for non-delivery. So one breach or default by the seller may be that he has agreed to deliver certain goods and later on he has refused to deliver the goods. So this non-delivery is a breach on his part, and the buyer can claim damages for the same because he has agreed to give the goods and now he is disagreeing to give you the goods, and buyer will have to suffer some losses because maybe his production will be coming to a halt, or maybe he has to procure goods from a different source and he has to make efforts to procure new goods, and maybe he will be able to purchase those goods from a new supplier source at a higher price. So all these losses that he is going to suffer because of higher price or because of additional charges or because of delay in production, etc., he can claim all these damages as compensation from the seller, because it is the seller's breach which has made this kind of situation come. So this is under section 57. The second remedy available is in case this non-delivery is not on the due date, but there is repudiation of the contract before due date. That means there is no actual breach, but there is an anticipatory breach of contract. That means the due date of delivery of the goods is yet to come, but seller, prior to that date, seller has informed the buyer that I will not be delivering you the goods. So this is called anticipatory breach. So in this situation, buyer has two options open to him. He can take a legal action for recovery of his price or recovery of his damages, etc., at the same date when this breach was intimated to the buyer, or he may also take the option of waiting till the actual due date and then to take action for recovery of his damages, etc., at that date. So in both the cases, the damages that he will be given, that will depend upon the date on which he takes the action. Like in case today he has decided to take action against the seller for non-delivery, in that case the damages will be equal to the market price on this date and the difference of this market price from the actual price which was agreed upon. Like for example, the price agreed upon was 10,000 rupees, and now today the breach was done, and now buyer will have to procure similar goods from the market, and in the market the price is 12,500. So this additional 2,500 charge will be the difference which he can charge from the seller as damages. And in case the due date was 2 months from now, then the damages will be the difference between the market price at that date, 2 months after today, and the actual price which was agreed upon between the buyer and seller. So measure of damages depends upon the date of taking of action for the breach. Another remedy which is available to the buyer will be suit for specific performance. Suit for specific performance is, there are certain situations wherein damages will not be adequate remedy for the buyer, because damages will be compensating you in case similar goods are available in the market, and you can have those similar goods maybe at additional price and you can suffer some losses, but those losses will get compensated in the form of damages. But what if those goods were specific or a certain goods, and such kind of goods are not readily available, or they were to be custom made by the seller, or damages are not going to be adequate remedy for the buyer, or the goods are of some special value, or they are unique good, they are some antique pieces, some rare goods which are not available elsewhere. So what kind of damages then you can charge? So in that case, the buyer can sue the seller and can request the court to give the remedy of specific performance, wherein at its discretion the court may order the seller to specifically perform the contract as he has agreed, and he will not be allowed to go on with the breach. So he will have to perform it. That is under section 58. Another remedy which is available is suit for breach of warranty, section 59. So there may be a situation wherein one of the warranties have been breached by the seller. So warranty we already understand, we have done the chapter of condition and warranty. Warranty is one of the term or stipulation of the contract which was of secondary importance to the buyer, and if seller has not fulfilled that warranty, he has made a breach in that warranty, then we have done that the buyer had a right to cancel the contract in case it is condition, and to ask for the damages in case it is a breach of warranty. So here also you can claim the damages for breach of warranty, and you can claim the cancellation of the contract, rejection of the goods, and you can get your price back in case this breach is that of breach of condition. So in this case, how he can get a suit for breach of warranty done? He may either recover damages, or in case he has yet to pay the price to the seller, he can ask for a reduction in the price equivalent to the damages that he has suffered because of this breach of warranty. So in this regard, we have discussed the case of Mason versus Birmingham in that chapter itself. So you can reuse that case here also. And the last remedy available to the buyer is suit for price and interest. Now in case there is a non-delivery on the part of the seller, but buyer has already paid for the price of the goods. So what in this case he can do is, although the seller is not giving you the goods and you may have to procure the goods from the market from a new supplier, but what about the price? So price that you have already paid, this price has to be refunded by the seller, and he is not doing it. So you can sue him for recovery of your price, and at whatever date the court will order to refund the price to the buyer, in that case if the buyer is able to recover his price, then the court may also allow you for interest because of delayed refund, because the price should have been returned by the seller himself when he refused to deliver the goods, but he has neither paid the price and also he has made refunded the price at a late date because of the order of the court only. So court will also ask the seller to pay interest from the actual date of payment of price when the buyer has paid that price earlier, and now the refund of price being made now. So the difference between these two time period will be making the buyer eligible and entitled to receive the interest also. But there is one thing to be specified, that the buyer will be able to recover this interest only if he is able to win the suit and refund of price is ordered by the court. So if he fails to get his price refunded, there is no question of getting interest naturally. So these are the remedies available to the buyer in case of breach. So that way this chapter had two parts. The major portion was with regard to the remedies available to unpaid seller. So in this case, in case question is about remedies for breach under sale of goods contract, you have to cover both the remedies for the seller as well as today's topics for the buyer. But otherwise, if the question is only talking about the remedies of unpaid seller, then you will restrict yourself to the previous lecture only. That's it for today. Thank you.